that at least I can highlight some of the obvious changes in these new forms. So a lot of things are going on that we need to be careful so as not to become a victim. But at the same time, the law has not changed. The law has remained the law. So if you have means of legal stay, you can still stay here without any problem. Okay, some of the changes in the new form, they are asking for just okay. They want to know when applicants enter the United States. This is a question that was there before, but the way they change it now, the question is asking, was your last arrival the first time you are physically present in the United States? This is a new question. What is your current immigration status? If it has changed since your last arrival, hold on, this is not even the part I'm looking for. Okay, they want to know your social security records. Have you earned up to 40 qualifying hours under your social security? They want to know if the level of your education. Remember, all these are not part of application for permanent resident before. In fact, you may not even have education at all if you are applying for family-based adjustment of status. There are lots and lots of new questions that were added to this new form. Part of what they want to know now, they want to know, prior to now, they always ask for the petitioner's tax return. But now they want to know beneficiaries' tax return. The problem with this is that a lot of people, in the course of filing taxes, they don't declare their immigration status. And one of the grounds of inadmissibility is when somebody falsely claims to be a U.S. citizen. A lot of tax software, they automatically select U.S. citizenship when you are filing your taxes. This is one of the things that I want people to pay attention to. If you have, because this is tax season, if you are not yet a citizen and you are filing your tax, make sure that the tax preparer indicate your status. If you don't have any status, do not claim to be a citizen. It is one of the grounds of inadmissibility. Unfortunately, there is no waiver for it. There's no waiver for it. It is one of those grounds of inadmissibility. Like I said, this is not even about Donald Trump. That is the law. The law is that if you falsely claim to be a citizen, you cannot get a waiver. There's no waiver for it. In the past, it used to be a grant for denial of citizenship, but during Donald Trump's first term, they extended it as a grant for denial of green card. And of course, it's back in place now. Biden tried to remove it, but it's back in place. So there are a lot of new things that are coming up under this new administration that we need to be aware of. And of course, there are so many executive orders. We have discussed this extensively in other things, but maybe I should just go over it as quickly as possible. The first one that affects everybody asking for any form of benefit, either in the US or outside the US, that is the executive order enhancing visa screening and vetting. So what that means is that every single application is required, that immigration is supposed to give extended screening, additional review to look at it with a second eye, to scrutinize it and not just approve petition just for the purpose of approving, irrespective of the grant for the petition. They also extended it to non-immigrant status like H-1B. H-1B, one of the executive order that affect H-1B, prior to now, immigration do not conduct site inspection for H-1B. But now, they are going to be conducting site inspection for H-1B. H-1B is when an employer, a secular employer, sponsors someone and file a petition, temporary working permit on behalf of an employee. That is H-1B. The religious equivalent of it is R1. But for R1, they have actually been conducting site inspections since 2009. But for H1B, they just extended it. Another thing that is changing is that whatever an employer indicates in a petition, the employer must stick to it. If anything is going to change, the employer must file an amended petition. This applies to both H1B and R1. Employer must file an amended petition, and that amended petition must be approved before the new position can take place. What that means in essence is that if you tell immigration that Law Office of, for example, Law Office of Oluwaseun is going to hire an attorney. The attorney is going to work in Arlington, Texas. If 6 months from now, if we decide to open a branch in Florida, for example, and we decide to post that lawyer to Law Office of Oluwaseun in Florida, what immigration is saying is that before that person can work in Florida, we must file an amended petition, and that petition must be approved before he can start in Florida. Going to Florida without the approval is a violation of status. Of course, because we are back to Donald Trump administration, one of the executive orders is actually an executive order that rescinded all the executive orders signed under President Biden. One of the challenges with that is that if you are new in this country and you are applying for a change of status to student, and your application, you have submitted your application, but your I-94 has expired while you are waiting for decision. Under this new policy, the change of status application is going to be denied. So in order to prevent it from being denied, when you apply for a change of status, maybe from visiting B1, B2 to F1, make sure you monitor your I-94. And before the expiration of your I-94, submit an application for an extension of your I-94. So you have to keep filing an extension until whenever there is a decision on the F1 application. Again, under Biden, we didn't have to do that. Under Biden, the only thing we need to do is to ensure that we submitted the change of status application before the expiration of the I-94. That is all we needed to do. Once you submit it, whether the application takes up to 1 year or more, you are still maintaining legal status. But under Donald Trump, they are saying that once you submit an application for change of status, you must be maintaining legal status. So you have to keep extending your current B1, B2 visa if you're on B1, B2, or whatever non-immigrant status you are in. You have to keep extending it until the approval of the new requested status. So another thing that one of the new executive orders, there are too many executive orders. I may not be able to touch on all of them because if I have to, I may not have I may not have time for questions. And I believe that being able to answer specific questions will be very, very vital because sometimes I may spend 1 hour discussing all these things. It may not address specific questions, but those who have specific questions, we want to be able to spend more time addressing it. But before I do all that, I just want to mention 2 more executive orders. The first one is the one that mandates BIA and Immigration Court, Board of Immigration Appeal and Immigration Court to expedite cases. especially non-detained cases. So if you are in removal proceedings and you are previously thinking of buying time, you need to do something right quick, because right now they are not granting time. I was in court on Wednesday. My client has a very what I consider a very viable relief. In fact, my client was a minister who has been he has an approved I-360 that has been approved for this client. The client luckily was able to file adjustment of status before the visa bulletin retrogressed. But because the visa bulletin has retrogressed, she is not able to get green card, but she has a pending adjustment of status. But again, you know that when people come in here, like I said, a lot of people patronize people who don't know what they are doing. They get side information. So this person applied for asylum before they got to me. So when they came to me, luckily they were still in status. And I told her, based on the information that she has provided, she's not eligible for asylum. And I explained to her that the asylum application is not only going to be denied, but she's going to be placed in removal proceedings. So luckily, before the expiration of the I-94, she was able to find a religious organization that was willing to file R1 visa on her behalf. So because she was a minister, ordained minister, so she was eligible. So we filed the R1 using premium processing. The R1 was approved. The removal proceedings was in court. 2 years after the R1 was approved, we filed I-360. The I-360 again was approved, and like I said, we submitted application for permanent resident, and these things were still pending. So when I got to court on Wednesday, I told the judge that, look, my client is in status, is maintaining legal status. We have a pending application for adjustment of status. However, when this application was filed, visa was current. Visa has now retrogressed. Therefore, I want the court to give us continuance so that at least let's wait for some time to see if visa will be available and my client will be able to get a green card. The judge said no. She's not going to grant the continuance. She said that the asylum application that is before the court, that even if we are looking for a long time, it's not going to happen. That we are going to get a hearing for the asylum thing shortly, and the court is not going to wait for any visa bulletin and all of that. So I tried to persuade the judge. I tried to be friendly, present all kinds of arguments why it would be unfair to go into the asylum when our plan is to withdraw the asylum and go ahead with the adjustment of status. The judge refused. So I said, okay, let's proceed. Now, it is the government that brought my client to court. It is the government that issued a document called Notice to Appear. That is the document that normally institutes removal proceedings. For those who have ever seen Notice to Appear before, it usually contains about 4 or 5 allegations. It usually has something like, you are not a citizen of the United States. You are a citizen of so-so-so country. You enter the United States on or before so-so-so date with authorization to remain until so-so-so time. You remain in the United States beyond the period authorized in violation of the law. So that is the way they always make that allegation. So they make it difficult for any respondent to deny any of the allegations. When they tell you that you are not a citizen of the United States, that's not something you can deny. When they tell you you are a citizen of so-so-so country, based on the passport that you use and the visa that you use, you cannot deny it. You enter the United States on so-so-so date with authorization to remain until the so-so-so time. These are things you cannot deny. You remain in the United States beyond the period authorized. Most of the time, you can't deny these allegations. And the problem is, once you admit those allegations, the judge is going to say that you have been found removable. And then the judge will ask you, what relief are you seeking? So I told the judge, okay, let's proceed if you are not going to grant continuance. So the judge asked me if I received the notice to appear, and I said yes. Are you ready to plead? I said yes. Okay, how do you plead to the allegations? So I told the judge that we admit allegations 1 to 3, but we deny allegation 4. The judge was furious that no, my client was already been here. She's not going to tolerate me wasting the time of the court, this and that. I said, Your Honor, with respect, it is the duty of the government to prove that my client overstayed, that my client is not in legal status. I'm not going to do their job for them. That's never going to happen. It is the government burden. They must meet that burden. Let them show evidence that my client is not in status. So the judge now turned to the government lawyer. And guess what? The government lawyer started giving excuses. Oh, I don't have the file here. Oh, I will need a continuance. The same continuance that I requested and the judge said no. The government lawyer requested the same continuance and the judge granted it. So I'm just giving you an idea of what is going on right now across the board, no exception. USCIS, Immigration Court, BIA, AAO, all these things are going on now, no exception. I have another example. A client who is already a permanent resident, he has a green card, but he was previously in removal proceedings, and for some reasons, he was ordered removed. He changed his name when things were easy, married a U.S. citizen, and applied for green card under the new name. For some reasons, they didn't link the two files, so the green card was approved. But now that there is problem, he is concerned because for those who listened to when I enumerated the enforcement priority, which I'm going to restate here today, he is one of the people that are at risk because people with removal order are part of the enforcement priority. So he's afraid now. So I told him that the only way we can solve the problem is that we have to get that removal order terminated. We have to file a motion to reopen. But motion to reopen must be filed within 90 days of the removal order. And we are talking about removal order that is over 20 years. So definitely it's not going to be approved. So the exception to that 90-day deadline is to file what is called joint motion to reopen. So I contacted the Office of Chief Counsel and presented all the evidence. This person, the wife is a U.S. citizen. They have 3 children. All of them are U.S. citizens. And he himself has a green card. So I explained all the situation. We presented everything. I got a response back. Sorry, we cannot join in a motion to reopen. So it is across the board. They are not agreeing to anything right now. So that is the situation. So before I start answering questions, let me quickly read the 5 enforcement priorities as they gave it to us. The number 1 on the enforcement priority, anyone who entered the United States in the last 2 years without inspection. For those of us who have been here for some time, you will recall that between 2022, 2023, there was a time that it was as if the border was open. People were just coming in with caravan. They were coming in large numbers. It got to a stage that the governor of Texas actually hired some buses and they were moving people from Texas to different states, what they consider sanctuary states, like New York, New Jersey, California. They were sending people to those states. So all those people that entered during that period, especially within the last 2 years, that is the number 1 on the enforcement priority. So if anybody entered during that period and they have not been able to do anything to fix their status, they are number 1 on that enforcement priority. The second set of people under the enforcement priority, those are people who entered without inspection at any time. Either it is within the last 2 years or within the last 10 years, and they don't have any pending relief. They don't have any pending application. They don't have anything pending, and they entered without inspection. They are the next on the enforcement priority. After that, the next one on the enforcement priority are those who have criminal conviction, those who have been convicted of criminal offenses. It is important to point out that criminal conviction is actually a major problem for anybody who is not a U.S. citizen. Even if you have a green card, if you committed aggravated felony, they will still take the green card from you and they will still deport you. So criminal conviction, that one is a major problem. So those are the third one on the enforcement list. The fourth one on the enforcement list are those with removal order. This is where this client that I explained the situation, this is where he is in trouble. Those who already have a removal order. In fact, as far as I'm concerned, they are more at risk than any other category on that list. The reason is that they already have a court order. So they could be picked up today and deported the same day. They don't need to take them through any court system. They will tell you, you have already gone through the court system. The judge has already ordered you removed. So they may pick up somebody and straight to the airport or to the border because there's already a removal order. Many of these people, those who file appeal at the time, the appeal has already been denied. So those are very risky. Then the last on the list, this one is interesting. The DHS told us these are people encountered by ICE. People encountered by ICE. What that means is that you don't necessarily have to be the target. Let's say my office here, let's say immigration decide to come and arrest Oluwaseun here. On getting to the reception, they meet maybe 2-3 people. They are going to ask everybody to identify themselves. Of course, they will identify themselves first. And of course, if they don't have a warrant, I will not even allow them to come in. This is a private property. I demand to see a warrant. But assuming that they have a valid warrant, they identify themselves and they show a valid warrant. Now, everybody they see around, they will ask everybody to identify themselves. So if anybody here does not have legal status, then that person too will be arrested, even though that person was not the person they targeted here. They came here specifically for Oluwaseun, but because those other people, they are not in legal status, they will still be picked up. So that is what is called anyone encountered by ICE. So those are the 5 categories of people that are high, that are risky. But for other people, for as long as you don't have criminal record, just lay low and you'll be fine. So, Pastor, I don't know if I believe that people will have started sending in questions. And like I said, yes, I think it's better to spend a lot of time on questions so that we'll be able to meet more need than general information.
Thank you so much, sir. You touched some of those things, but I have some questions here. I'll be asking them one after the other. Once you answer the first one, I will go to the second one. The first one that I have here is, which I think you touched briefly, is what form should a graduating medical student fill? She's currently on DACA. What should she do?
That's a very good one. Because unfortunately, DACA, this was even before Donald Trump came in. A federal judge in Texas actually ruled last year, December, that DACA was unconstitutional. Remember, DACA was a creation of the president. It was President Obama at the time. DACA was a creation of an executive order. It was not a law passed by the Congress. It was a creation of executive order. So because it was a creation of executive order, the Republicans challenged it in court. And of course, they have been going forth and back over it in court. During Donald Trump administration in 2016, I remember he wanted to remove DACA. But maybe it was the protest at the time or something. Subsequently, he just decided that, okay, we will not accept new application, but those who are already on DACA, we will leave them. But when Biden came in as president, Texas sued the Biden administration again on DACA, that DACA is unconstitutional and they needed to stop it. So in December, last December, a federal judge in Texas ruled that DACA is unconstitutional. However, he went on to say that for those who are already on DACA, they should allow them to to stay on DACA until the expiration of their status. However, they should not approve new ones. That was the ruling. We are still waiting to see what Donald Trump is going to do about it, because I know that there is a lot of pressure even on Trump to do something about DACA, considering the fact that the beneficiaries were people who were brought into this country as children. So whether he will do it or not, we can't say. We are still waiting. However, a lot of people had the opportunity to adjust to green card during Biden administration. One of the things that led to this court case in Texas was that Biden administration also granted an executive order that allowed DACA recipients to be given travel document. And once they are given travel document, they go out and re-enter with that travel document. They can now adjust if they have a valid basis to adjust. For example, if they are married to a U.S. citizen, because the only thing that prevented them from adjustment is that illegal entry in the first place. So if they are able to go out and come back in with that advanced parole, they were able to adjust status. So it was that executive order that triggered the lawsuit. That was what triggered the lawsuit. But those who were fast enough at the time, I remember we were able to use it quickly for a few people at the time, and they were able to get their green card before there was an injunction. Then the court ruled that even that executive order allowing somebody who is parole to adjust was not even constitutional after that. But again, some people escape it, some people don't. So in view of that, it's going to be tough for somebody on DACA to adjust right now. It's going to be extremely tough. And honestly, at this time, I don't have an answer at this time. We are just waiting to see how the new administration is going to treat DACA. But if you have a current one, you can still continue to use it until whenever we know where we are going on DACA.
Thank you, sir. The second question, which I think you'll touch on briefly too, is I am a religious worker with an approved I-360, and I had applied for my I-485 with priority date of April 8, 2021, and I have not heard from USCIS till now.
This person has a lot of waiting to do, because they just released the visa bulletin for March, and guess what? The religious worker category retrogressed back to 2019. It was previously the February bulletin, it was 2021. We were hoping that it would move forward, but rather than move forward, it actually moved backward 2 years. They are back in 2019. Let me see if I can give you the exact date.
So,
they just released the visa bulletin this week. It's so funny that, I mean, the way immigration is going, we just hope that Trump will, maybe after all this enforcement, he will be able to do something, because Trump is actually in a unique position to do it, considering what I consider his grip over the Republicans, and considering the fact that Republicans control every essential element of the government right now, House of Reps, Senate, and the presidency. So if they really want to do it, they are in a position to do it. We waited for Biden to do it in 2020 when he was in a similar position, presidency, Senate, and House of Reps. Unfortunately, they didn't. So fourth category, yeah, now it retrogressed back to August 1st, 2019. So this person still have to wait because by law, USCIS cannot approve the green card until visa is current. That is the law. That's not a matter of executive order. That's the law.
The third question, which I think some people are grappling with, is it compulsory that you should have visa on American passport before traveling to Nigeria?
No, we have answered this question several times, but because this is a different forum, I'm going to restate it again. Let me say this. As I said, in the days of social media, there is something called influencers. Some people, in an attempt to attract people to their page, to watch them, to like them, to do, so they come up with all kinds of sensational issues. I actually did a reel where I said specifically that I have investigated this Ivorian woman thing, and it is false. And nobody has come out to challenge me. It is complete fabrication. It never happened. Now, let me address what the law says. The law says that a US citizen must use American passport to exit and enter the US. That is what the law says. However, American government does not have any machinery in place to monitor Americans who are going out of the country. It is only people coming into the country that they monitor. CBP, ICE, or any DHS personnel does not look at Americans going out of the country. So that role is given to the airlines. So now, if you are a US citizen and you are a dual citizen, what I have been doing for ages, and I still do, and I will continue to do, depending on the country where you are going, bring out your American passport. I'm a Nigerian, so let me use Nigeria. Bring out your American passport. When you want to check in with the airline, bring out your American passport, give it to the airline officers. They will check your ID, they will verify it with the ticket, and then they will swipe the passport. Now, when they look at the passport, they realize there is no visa. They will ask you, oh, your final destination is Nigeria. I don't see any Nigerian visa here. How are you going to get to Nigeria? Then you bring out the Nigerian passport. Oh, I'm a dual citizen. I'm going to use my Nigerian passport. So they will look at it, review it, and return it to you, return both of them to you. Now, when you show that your American passport, you have fulfilled that law that says that you must exit with American passport. Now, it is not the responsibility. In fact, American government does not have the authority to control how anybody enter a foreign country. Whatever document Nigeria will accept for people to enter Nigeria, that is not something American government can pass a law on. Are you following me, sir?
Yes, sir.
So American government cannot tell Nigeria, oh, somebody coming to Nigeria must use a visa. That is the responsibility of the Nigerian government to determine who comes into Nigeria and who does not come into Nigeria. So the moment you give the airline your American passport, you have actually satisfied that requirement of the law that says that you must exit with American passport. Of course, when you get to Nigeria, bring out your Nigerian passport. When you are coming back, now fulfill that law that says you must exit and enter with American passport. It's as simple as that. However, let me say this. I was involved in another seminar like this recently, and one of the speakers said that he had an experience. I'm not going to dispute it. He said that in his experience, the airline maybe he gave them both passport at the same time. I don't know. But he said that the airline swiped the Nigerian passport instead of the American passport. So when he was returning to the US, he gave them the American passport at the port of entry. And then the CBP officer told him that, but the record shows here that you are a Nigerian. He now said, oh, but you can see that I'm American, I'm a dual citizen. He now told him that, well, they must have made a mistake. Then the officer now changed it to America. But what I see from that is that probably he gave them both the two passports together and then they swiped the Nigerian one. I really don't know what happened, but that was his own experience. But the way I normally do it, and I've been doing it for years, this is not even because of Trump. That's the way I normally do it. If I'm going out, I present my American passport. It is only if they ask me about visa or about how I'm going to get to my final destination, that is the only time I bring out my Nigerian passport.
Thank you, sir. That's well taken care of. So are there any expectations at the point of exit or entry to the US if one travels to Nigeria on a conditional green card and with a pending I-751 application?
Yes. There are two, well, I'm going to clarify it, because when we are saying I-751, there are two types of I-751. There are two categories of people who get conditional green card. Those who are married to American citizens and the marriage has not been up to 2 years, they get a conditional green card. There's another set of people who get conditional green card. Those who invested, those who obtain green card through investment. And the green card, usually when you apply for green card through investment, you get initial 2-year green card. The reason is that when you are investing, you are telling American government that you are going to do this with your investment. The law requires that every investor, the investment must create minimum of 10 American jobs. So when you are doing the investment, you can't create the job immediately. So it's like a promise. It's like a proposal. We are going to do this. We are going to do that. So they don't have a way of knowing whether you will actually do it or not. So they give 2-year green card, conditional green card, so that at the end of the 2 years, when you apply to renew it, you now have to present evidence that everything you claim you are going to do, you actually did it. So if you are talking about conditional green card, for those in that category of investment, there is nothing to worry about. You can continue to use your green card in and out. There is no problem. In fact, I have an investor whose green card has not even been approved, and we already filed a lawsuit against the Department of State that they are delaying his green card. I mean, they can do that. It is their money. They are bringing their money to invest here. They are creating employment for America. So the America have to give them priority. On the other hand, those who have conditional green card based on marriage, yes, you have to be careful. You have to be careful in that, because it is based on marriage, at the port of entry, if you travel and you are returning, the CBP officer can decide to check out your marriage. They can call your petitioner, they can call your spouse to ask questions. I mean, this is what I do for a living. So we have seen all kinds of scenarios. I've seen a situation where CBP officer, somebody traveled and was coming back. The CBP officer said, oh, when did you travel? Oh, about 3 weeks ago. Okay, where's your spouse? Oh, my spouse is at home. Is he coming to pick you? Well, he should, but maybe he's at work. The officer pick up the phone and call the spouse. Oh, where's your husband? He's at home. Which home? What address? The wife provided the address. This is somebody who was coming from Nigeria, and the wife is saying that the man is at home. So what does that tell the officer right there? Something is not wrong, and something is not right. Is either the marriage is fraud or something is not right. So what am I saying? If you are using a conditional green card to travel and your green card is based on marriage, you have to put your house in order before you travel. Make sure that your wife knows everything about your movement so that when they ask questions, you will be able to answer.
Thank you, sir. The next one is, if you are waiting for your green card before now, are you still safe?
As in, if you have a pending application for green card is legal. Once an application for green card is pending, you see, irrespective of what you are using, anybody applying for green card inside the US must use Form I-485. That is the only thing. Whether you are applying as an investor, whether you have an employer petitioning for you, whether you file NIW, whether you got asylum approved, whether your parent, irrespective of, even if you won the lottery, anyone who is present in the US and is applying for green cards must use Form I-485. So Form I-485, that is what employment authorization is attached to. So if you have a pending application for adjustment, you are maintaining legal status.
Thank you, sir. The next question is, what action is needed for a situation where approved candidate you filed for died?
Oh, who died? The petitioner? I didn't get the question.
Oh, okay. What action is needed in a situation where approved candidate, somebody you filed for, now died? The person you filed for, maybe in Nigeria.
So that's the beneficiary.
The beneficiary, yes, correct.
Okay, yeah. The petition is dead. That's it.
Okay, that's it. Okay.
The petition is dead. The same thing with the petitioner. If it is the petitioner that died, the petition is dead. However, in the case of the petitioner, if the beneficiary has an immediate relative who is in the same category, the beneficiary can apply to immigration to reinstate and substitute the petitioner. In other words, let's say a U.S. citizen petitioning for a child. Let's say a U.S. citizen father petition for a child, and then that petition is pending. Then the father died. If the mother is a U.S. citizen, although upon the death of the father, the petition terminates automatically, but the beneficiary can actually request USCIS to reinstate the petition and substitute the mother, who is also a U.S. citizen, as the petitioner, instead of having to start all over again. So this is a discretionary thing, and it is reviewed on a case-by-case basis.
Okay, sir. Now, the next question is, what is the correct priority date for EB2 NIW?
National interest waiver. I just opened the priority date. Let's see. NIW right now is May 15, 2023. May 15.
Okay, sir. Then the next one is this.
So what that simply means is that any petition, any I-140 petition that was filed on or before May 15, 2023 can apply for green card now.
Okay. So if someone is out of status and they marry an American citizen, any information about them?
Yeah, when somebody is married to an American citizen, the law allowed the period of unlawful status to be waived. The only condition is that the initial entry must be lawful. The initial entry, let's say somebody entered with a B1, B2 10 years ago and has been out of status since that time, and then in 2025 decided to marry a US citizen. Yes, the person can still adjust.
It's if someone who filed for asylum completed all hearings and is waiting for final judgment, is the person vulnerable to an arrest, or does he need to file an extension of B1, B2?
I'm assuming that, if I understand the question correctly, I'm assuming that this person is talking about hearing at the immigration court.
I want to believe so, sir. Is that
Aha.
so?
No, the person is not in danger of immediate arrest. The reason is, even if the asylum application is denied, the person still have a right of appeal. You can still file an appeal within 30 days of the denial. So it's not yet time to be fearful.
Okay, sir. Then this one, my
Is this my... We can't hear you, sir. I'm
I
sure it's
think
not from me.
I think
Okay.
it's freezing. Yeah, Pastor, there. So
I think it's frozen.
yeah, it's freezing. Okay. All right. Let me call.
I think the question that person want to ask was that if somebody's work authorization has been revoked, what's going to be the next line of action? But it still remains a smaller part to conclude. Maybe when he gets on, he can ask that question fully. But if somebody's work authorization is being revoked, what's the next line of action? Thank you.
Well, I think I will need to have the full question, because work authorization can be obtained on several grounds. And of course, depending on the ground, like the last question about asylum, if somebody has a valid work authorization based on a pending asylum, and then after trial, the asylum application is denied, if the person file an appeal, the work authorization continue to remain valid. Even if the work authorization expire while the appeal is pending, the person can still renew it. On the other hand, if the work authorization is based on family-based petition, let's say it is based on a U.S. citizen petitioning for a spouse, if the appeal, if that case is denied and the person file an appeal, the work authorization remains valid. But when the work authorization expire, USCIS will not renew it. Even while the appeal is pending, they will not renew it. But in the case of asylum, they will renew it when the appeal is pending.
Yes, sir. Yes, sir. Another question, sir, is someone who has work authorization with advanced parole. What advice do we have for that person regarding traveling outside the country for family emergencies?
Well, that's a very good question, because it is important I'm going to clarify three sets of scenarios. Number one, travel document is a discretionary relief. There are certain things that is not of right, but a discretionary relief. So one of them is travel document. So if you enter the United States without inspection, and one way or the other, you are able to get employment authorization, but you don't have a green card yet, under this new administration, I will advise you, don't use it. If you do, you will be at risk. I'm not saying they will stop you, but you will be at risk. It's going to be a 50-50 chance, depending on the CBP officer that attend to you at the port of entry, but you are going to be at risk. If you have never been out of status, let's say you got here on a B1, maybe before the expiration of the B1, you change to F1, maybe before the expiration of the F1, you change to something else, and then subsequently you apply for adjustment, and then you got a travel permit. You can use it without any fear of fine. You can continue to use it. Nobody can stop you at the port of entry. If you entered legally and you are out of status at some point, but maybe at the end of the day, you got your employment authorization or travel document through VAWA. If you travel, you will not be at risk. They give a kind of, I don't want to say priority, but there is a form of soft landing for VAWA applicants. Even from removal, there's a soft landing for anybody with VAWA. So those ones, there's no problem. However, if you have been out of status, and especially if you don't have a viable relief, and when I say viable relief, including those who are married to a U.S. citizen, I just gave an example of somebody with a conditional green card. If you don't have a viable relief, you may be coming back, and then CBP officer may decide to conduct interview regarding your marriage. Remember, they have access to public record. Right there, they can verify if you are actually living together with your spouse. There's a lot of things that they can see. And then if they believe that the marriage is not a good marriage, they can prevent you from re-entering. So it's risky. But the general, my general advice is that if you have been maintaining legal status, or if your case is VAWA, if you have advanced parole, you can use it without any fear. But if your situation is such that you are not sure, please don't use it. It's better to wait and get your green card. More importantly, if you have a pending asylum, I will not advise you to travel. The reason is very simple. By law, USCIS cannot deny application for asylum. If they don't believe your story, the only thing they can do is to put you in removal proceedings. If you are in removal proceedings and you travel out of the country, it is called self-deportation. So if you have asylum pending, it is risky to use travel document under this administration.
Thank you, sir. Somebody is talking about asylum now. Somebody is on a pending asylum and recently has a RN license and got a company willing to file EB3 visa for her. Is it wise to accept the offer at this time?
Well, again, it depends on a number of factors. This is a very, very technical area of law. I've seen even lawyers argue with me that this is not possible, but unfortunately, it is possible. It is what I've done multiple times. If you apply for asylum before the expiration, I didn't say within 1 year. Asylum, you must apply to be eligible for asylum, you must apply within 1 year. That is not what I'm addressing. But if you apply before the expiration of your I-94, and that case is still pending, either with USCIS or with immigration court, if the case is still pending and you apply before the expiration of your I-94, yes, if you become a registered nurse, you can take the job. You can still get your green card.
And so that takes us back, sir, about the medical student that we talked about the first time we asked the question. If she filed EB visa, can she be given green card, or is it advisable for her to file for EB visa, whatever they call it, the category of visa or green card?
It depends on what she's eligible for. Okay. Let me say this. The fact that somebody is a medical doctor does not make the person qualify for EB2 or EB1. It depends on what they are qualified for. But let me also give you this free advice. If I am a medical doctor that have been maintaining legal status up to this point, what you need to do, try to identify underserved areas. There are so many underserved areas in the United States. There are different programs that medical doctors can use to obtain green card through underserved areas. Unfortunately, a lot of people want to stay in the city. But all those underserved areas where they will not see one doctor to agree to work there, just locate them, go and work there. There are special programs for people, for doctors to get green card through underserved areas.
Thank you, sir. Another question is, an asylum case was filed in 2016. Do you know the priority date? I mean, how far are they on it? And is the person safe?
Well, if the application is still pending, the person is safe. However, for asylum, the issue is not priority days.
Okay.
The issue is Trump administration. When Donald Trump became the president in 2016 and he was sworn in January 2017, they started a serious enforcement just as they are doing right now. So because of the enforcement at the time, a lot of people out of panic, they started applying for asylum just to be able to show that they have something pending. Then the Donald Trump administration in 2017, they realized that people were just submitting frivolous application for asylum just to be able to get employment authorization. So the DHS secretary at the time, they introduced what is called last in, first out. Normally, immigration applications are processed in the order in which they are received. In other words, first come, first serve. That is the normal rule. But at that time, they changed the rule just to discourage people from applying solely for the purpose of getting work authorization. So they introduced last in, first out. In other words, effective that 2017, I can't remember the exact date, whether it was February 15 or so. Effective 2017, they introduced that last in, first out. So what that means at the time was that as soon as you file your asylum application, within 2 weeks, they will call you for interview. So once the application is denied, they put you in removal proceedings. So when people started realizing that people are getting into removal proceedings, people stopped applying. That thing worked. However, it disrupted the entire line. Remember, there have been applications that have been that were submitted prior to that time. So they disrupted the whole thing. So now, when Biden became president, Biden wanted to go back to the normal procedure, which is first in, first out. So you know that to destroy is very easy, but to fix is very, very difficult. So throughout his 4 years, they have not been able to fix it. They are still working on it. Then Trump came back again now. So that person's application was actually locked in because of that change of last in, first out. That's what affected it. It's not about visa bulletin.
Yes, sir. Next one, sir. Is any asylum seeker who is on a removal proceeding waiting for court judgment safe now?
Well, they just have to be sure that, waiting for judgment, that means there's already a trial.
Yes.
So it depends on how strong the case is. If it is a strong case, yeah, they are okay. But if it is not a strong case, they need to start looking for alternative. But right now, they are still in status. They cannot be removed. And like I said, even if the judgment comes and it is not favorable, they still have the right of appeal.
Thank you, sir. If a person got his or her work authorization through R1 and the work authorization has been revoked, what can the person do? Is the person safe from arrest?
If it is through R1, the person still have to find a way to continue to maintain legal status because, like we said, R1 transitioning into 360 right now, visa is not current for 360 so as to be able to file application for green card. So if it is R1, the person has to, you said the work authorization was revoked. So that means it is the R1 that was revoked.
Yes.
If the R1 was revoked, then the person is out of status.
So it's not
the person is out of status.
Thank you, sir. Then if someone applied for EAD after 180 days of pending asylum and got denied for this reason, that it has not been decided and who is eligible to apply for employment authorization under 208.7 of this chapter because the 150-day period set forth in that section has been expired. Employment authorization may be granted according to the provisions of 208.7 of this chapter in increments to be determined by USCIS and shall expire on a specific date, or has been recommended for approval, but who has not yet received a grant of asylum or withholding or deportation or removal. What should the person do?
Well, you see, asylum is a little technical. There is something called asylum clock. The fact that you file your asylum application does not mean that the clock is running. There are so many things that stop the clock. And one of them is change of address. One of them, for somebody who is in removal proceedings, is when if you have a lawyer, when your lawyer is asking for continuance, or even if you don't have a lawyer, if you appear at an immigration court and the judge asks you, oh, you don't have a lawyer, do you need time to get a lawyer? And you say yes, they will freeze the clock from that moment. So to you, you may be counting the 180 days, whereas the system may not count 180 days. Now, how do you know whether you have already accrued the 180 days or not? The easiest way to know, go to let me see. Let me give you the exact number to call. Okay, please write this number down. 1-800
1-800
898
898
7180.
7180. 1-800-898-7180.
Okay, now I'm going to do it on my phone. You will see what is going to say. Then I'm going to tell you how to navigate it. Let me call that number.
You have reached the EOIR Automated Case Information System. To continue in English, press 1. Select 3. Welcome to the Automated Case Information Hotline. The following information relates to the primary case only. Individuals who are under consideration for or who have been granted benefits under Immigration Accountability Executive Action must appear for any scheduled immigration court hearings. Please contact your local court if you need bond hearing information. The alien registration number, also known as the A number, begins with the letter A and is followed by an 8 or 9-digit number.
Now, I cannot go beyond this point because the next stage is to enter the alien number. So if you put the alien number there, it will confirm the person's name, and then it will tell you where you are in the, if for example you have a pending case and maybe that case has been scheduled for hearing on April 5, it will tell you that this is the person, this is Olu Ashekun. Your case is set for May 5, 2025 at the Dallas Immigration Court, 1100 Commerce Street, Suite 1060, on so date before Judge so. Now, it will ask you for case processing information, press 1. For asylum clock, press something. So when you hear the asylum clock, press it. It will tell you how many days that has accrued. So you may be thinking your case has been pending for 2 years, whereas the asylum clock may have it like 90 days.
Yes, sir. So still talking about the asylum case, sir. Can asylum seeker apply for financial or any other benefit?
Well, they allow benefit for people who have been granted asylum, not who is still pending. People who have been granted asylum.
Then the next one is somebody says that their parents-in-law hold green cards but left the U.S. after the mother-in-law's pass, or the mother-in-law's grandmother's funeral, and they have not been back for 3 years. What would you advise they do? Can they change it to a B1, B2?
You see, I'm going to suggest something. I can't guarantee that it will work, but I'm just going to suggest it. There's something called SB1. SB1. And there's another thing called I'm trying to remember the word that we normally use, something folio. You see, he can apply for this at the US Embassy. Either the green card has expired or the green card is lost or anything like that. In the application that will be submitted and the affidavit that will be attached to it, the person will say that he or she does not intend to abandon the permanent residency. And of course, we'll explain why it's outside the US for those extended period of time. And then ask for a re-entry permit. If approved, they will give this person a visa that can be used only once, one-time use. So when you enter the US, you apply to renew the visa. But here is what I'm going to say. If you are still in the US, especially for old people, parents, and all of that, if you know that you are going to be outside the US for an extended period, it's not a difficult thing. There's something you can apply for. It is called travel document for permanent residents. So USCIS will give them a passport. DHS will give them a passport which they can use. If they have that passport, they can stay out of the US for 2-3 years, no problem, no questions asked when they are coming back. Unfortunately, it is ignorance. A lot of people don't know that all these things exist. So they just go and get into problem with their green card when all they need to do is to apply for that travel permit. And for that travel permit, you don't even need to wait until it is approved. The only condition is that at the time you apply, you must be physically present in the US. So once you submit the application, sometimes they ask them for fingerprinting, sometimes they waive the fingerprinting. After that, you can go. And it doesn't matter how long you stay out of the country, your green card will be safe.
Yes, sir. Earlier on, so we talked about a case where we asked a question about someone who wanted to travel with a conditional green card because he has a pending I-751. If the I-751 is based on violence against women with pending divorce, are there any concerns?
There's no such thing. There's no such thing under immigration law. You cannot base. There are two ways to file 751. You can do application that is a joint petition to remove condition. That is one. The other one, you can, did I say two? Sorry, three. There are 3 ways to file a removal of condition. You can file it jointly with your spouse. It is called joint petition to remove condition. The second one, you can file it on your own based on good faith marriage. What that means is that you enter into this marriage in good faith, but the marriage didn't work. The law does not require that a marriage must work, but the law requires that the marriage must not be entered into fraudulently. So in other words, it must be in good faith. It just didn't work. So that is the second way. The third one is to show that you experience cruelty. Maybe that's the one that the person is talking about.
Violence. Maybe that's
that you experience cruelty in the marriage. The truth of the matter is that it doesn't matter any of the 3. If your 751 is based on self-petition, then you don't have that risk, because most of the time in your application, you will have told them that you are not together anymore. So if you are filing a self-petition, they are not going to be calling your wife if they already know you are not together.
Yes, sir. So we will be rounding off in the next 3 minutes, sir. So I will take only 1 or 2 more questions so we can wrap up. So I know that you are busy. Any other question that we have, I will definitely reach out to you, sir, if we need further clarification or follow-up. So the other question that we want to quickly take is that somebody whose I-140 has been pending for 11 months. Any advice for that person?
I-140. You are frozen, sir. Okay, I think you are back. I didn't get the question, sir.
Oh, yes, sir. Somebody who is on I-140, what is your advice for?
This thing is frozen, but I think I had I-140.
Yes, sir, I-140. Yes.
But the thing is, it depends on the category, because I-140 is a form that is used for several things. It is used for EB1, EB1A, alien of extraordinary ability. It is used for EB1-2, that is aliens in management position in a multinational company. It is used for EB2, national interest waiver. It is used for EB2, labor certification. It is used for EB3. So I-140 is used for several things. Now, on the issue of visa bulletin, all of them have different priority dates. For example, EB1 is current right now. I got an approval for somebody yesterday, and I've called the person. The person is outside the country. I've called the person. If you have visa, I will advise you come and apply for green card from here. But if you don't have visa, then we will have to do consular processing. But consular processing will take years. I have consular processing that have been pending since 2022. And here we are, even after approval and everything. Here we are. I just mentioned previously how one investor filed a lawsuit against the Department of State that is taking too long. Because this particular investor invested his money since 2018. And here we are in 2025. Visa is still not able to attend an interview. So some are current right now. So it depends on the category. So for EB2, I believe I checked that previously. EB2 right now, May 15, 2023. For EB3, December 1st, 2022. For EB3, like a registered nurse or some other skilled workers, February 1st, 2021. And of course, for religious workers, which is EB4, August 1st, 2019. Of course, for investors, it is current. And for EB1, it is current.
Thank you so much, sir. We have been on for the past 90 minutes. I wouldn't want to take another extra 1 minute of your time. I just want to first and foremost thank you for taking time out of this busy schedule, especially in the time that we are in. We know that things are somehow. It's a very challenging time, very difficult time, but you graciously agree to do this for us. Thank you so much, sir. On behalf of our provincial pastor, who is our special assistant to the Continental Batia, is online right now, Pastor Mr. Loedi. We just want to say thank you, sir, for your time. Thank you for the insights you have provided tonight. Thank you for all the questions that you are able to take within the limit of the time that we had tonight. Every other questions, like I said, sir, I will send them as text to you, and I know that I will get response, and I will pass it on to those who are asking those questions. So thank you so much, sir. And I want to thank our provincial pastor too for allowing us to have this, and all our provincial leadership, zonal coordinators, and all parish pastors, and everybody online tonight. I know that we have so many questions. I mean, time is not our friend. We may not be able to answer all of them, but thank you for the insight that you have provided tonight, and we thank our leadership for this opportunity, for this platform. Thank you so much, sir. And I will definitely be in touch. Thank you, sir.
We thank God. Before I go, I also want to say this. Because I came a little late.
Yes, sir.
I promise that any question that came tonight,
Okay, sir.
If you send them to me, I will answer it.
Thank you,
Any
sir.
question that came tonight
Yes, sir.
that is not answered yet, I will answer it.
Okay, so you want me to continue right now?
Oh,
I'll send them to you as text.
as in if you send it, I will
send it.
respond.
Oh,
Yes, sir.
thank you, sir. I will send them to you as text, sir. So when I get the answer, I can relay the answers back to those who asked the question.
Yes, sir.
So
because
thank you so
I also
much,
see that some people have left already.
Yes, thank you so much. It's been 90 minutes, even though time goes by so fast. Thank you so much, sir. We just want to thank God for your insight. We thank you for your expertise. We know that time is money, and thank you for finding time to be with us tonight. We really appreciate it.